Okay, let's get started. Good afternoon, everybody who may be joining. My name is Matt Cruz. I'm one of the partners here at the firm Beresford Booth. I head up the probate and planning group here. Thank you for joining us. Our topic today is going to concern estate administration. Rather than get into all the nitty gritty, I thought what we would do is give an overview. Hopefully, it's helpful to anybody who's engaged in an estate administration or may become responsible as a nominated personal representative or a trustee to commence an estate administration. I'm going to give you a few thoughts that I think are important. They come from a variety of client experiences I've had in commencing, literally hundreds of if not more than that, estate administration projects. So I've got a few important thoughts I think that might help everybody understand the process a little bit. And so I've got a few thoughts to share, but mostly this presentation is going to be really a round robin kind of communication or discussion between Per Oscarrson and myself. Per is a longtime member of our firm and quite experienced attorney, as is Sarah Smith, who's joining us. The three of us make up the principal parties of our planning and administration group here at the firm. By the way, you're free to ask questions. I'm not sure whether time will allow us to get to all the questions during the presentation today, but we'll certainly do our best if you'll include some kind of contact information to respond to any of your questions that we don't get to after today's presentation. By the way, I don't expect to keep you more than 20, 30 minutes or so. And of course, you're free to drop off anytime you like. Well, let's start then. One of the things that people always ask me about is what is probate? What is estate administration? What do we need to do? When do we need to do it? And I always respond this way. Whenever somebody has passed, there is need to administer their estate. Depending on the nature of the estate, sometimes the needs are small or the needs are greater. But all estates should be administered at or near the time of death, because to take responsibility to properly administer an estate at or near the time of death will avoid future problems. Many people will pass their estates not be administered, and then 10, 15, 20 years down the road, an issue pops up because maybe a piece of real estate is going to be sold and the decedent's name still appears of record. So the administration process will take care of that problem and allow the property to be freely conveyed at that time. And as everyone can likely imagine, if you waited even 5 or 10 years to administer somebody's estate upon the conveyance of real property, there's a lot of lost information or difficult information that's difficult to find that would make the subsequent sale a more challenging process than had you gone through the appropriate administrative steps at or near the time of the decedent's death. The other comment I often give to folks too is it's easy to understand why estates are not administered at or near the time of the decedent's death, because there's no entity out there that I jokingly refer to as probate police. If an estate should be administered by a surviving spouse, for example, nobody's going to come knocking on their door to say, hey, you didn't change this bank account, or you didn't change ownership of this real estate or these other properties, or you didn't deal with these debts through a formal administration. So it's very easy sometimes to continue operating in life. And of course, the surviving family members and friends are still grieving and often don't want to take up the business of estate administration, only, as I mentioned a moment ago, to find out several years down the road when something needs or wants to be done with an asset that there are some problems, some title problems or ownership problems to then overcome. And given the passage of time, sometimes that can be challenging. So when people ask me about estate administration, I tell them it always involves the same 4 elements. The first is you got to figure out who's in charge, who's supposed to be responsible to take charge of the decedent's estate and conduct all that needs to be done to properly administer the estate. The second thing is really the duty of the person in charge is to gather the assets of the decedent, make sure you control them, make sure you possess them, make sure you know what they are. So you've got to gather the assets. Then what you've got to do basically, and conceptually, broad terms, you've got to pay the bills. Once the bills are paid, then you've got a remainder estate that can be distributed according to the will, if the decedent died with a will, according to the decedent's trust, if a trust exists, and sometimes both exist. But if no will or trust, then the estate will be distributed by law. We refer to that as an intestate distribution. So whether you've drafted or implemented a will or a trust to dispose of your estate or not, the law, if you have, your will or trust will govern the administration of your estate. But if you haven't, your estate will be governed by the law. And people commonly ask, well, if there's no will or trust, does that mean the assets in my estate go to the state of Washington or just somehow vanish? And the answer there is no. There are limited circumstances where assets could go back to the estate of Washington. That's a process called escheat, but it's rare. I've only seen it a few times in my career. It rarely happens. Usually your estate is going to be distributed, if by law, to your nearest surviving blood relatives. That's the premise of the law that would govern the distribution of your estate, unless you had a will or a trust. Okay, so those are the four things. Whether you've got a will or a trust, it doesn't matter. The four things that must be addressed conceptually: who's in charge? Have you gathered all the assets? Have you paid all the bills? And then how are you supposed to distribute the remainder of the estate? By law, by will, or by trust? Conceptually, that's all estate administration is: appointing somebody to be in charge who gathers the assets, pays the bills, and distributes. Now, there's a lot of detail that can go with serving those purposes, but in essence, those four things are what's accomplished or need to be accomplished by each estate administration. Now, a common question I get is, what is probate? Well, probate really is just the judicial oversight of the process I've just outlined: determining who's in charge, gathering the assets, paying the bills, and distributing the rest. Probate is just the judicial oversight that all of those purposes have been accomplished and accomplished properly. Now, let me say a word about judicial oversight. We're fairly blessed in the state of Washington that we have a streamlined system of probate, which is to say, under appropriate circumstance, the court does not have to be involved very often to make decisions or approve decisions. If in a will or a trust, the personal representative or the trustee has been granted, essentially one way or the other, non-intervention powers, that means that the fiduciary has the opportunity to make decisions, gathering the assets, paying the bills, and distribute the rest of the estate by virtue of their own judgment, their own decision-making. That doesn't mean it's arbitrary. They must follow the law in going through these steps, in meeting the requirements of each of these steps. But it does not require, with the grant of non-intervention powers, that the personal representatives seek court approval along the way. Now, there's a form of court approval normally that happens at the end of the estate administration when the estate is closed. That's when the court comes back in, and if no objection is filed by any interested party, the estate can be closed based on the final report the personal representative files with the court, called a declaration of completion. If there is objection, then the estate cannot close until the objection is resolved. And some of you might be thinking, well, how do I know if I can even object or if I have a concern? Well, along the way, typically the personal representative will provide an estate inventory and an accounting and an opportunity for you to review the expenses the estate has incurred and indicate what your distributive share of the estate is going to be if you're an heir or a beneficiary of the estate. And you'll have all the information you need. And based on having that information, you'll have an opportunity then to assert any objection or concern or ask for additional information before the estate is closed. So the estate cannot be closed as a general matter before all of these issues are approved, all the creditors agree they've been paid, and that kind of thing. Now, there's some exceptions and some problems, of course, that come up along the way. But as a general matter, if you're an heir or beneficiary of an estate, the estate cannot close until you've agreed with the accounting and your distributive share calculation. Okay. And so in terms of court intervention, really the only time, well, I shouldn't say the only time, the court can be involved in estate administration for a number of reasons. For example, there could be a dispute associated with gathering the assets, or even really who's in charge. It could be unclear by the will or the trust, and there could be various parties competing to be nominated as the administrator or the personal representative of the estate, and that could give rise to a dispute. But in gathering the assets, in paying the bills or distributing, there are opportunities for all kinds of disputes to arise. And if disputes do arise in any of those phases, the estate is going to have a court-appointed representative by virtue of commencing probate and having the court appoint the representative to deal with those disputes. Well, what am I talking about? Gathering assets. Well, there could be jointly owned assets where the other joint owners, there's some dispute with them about the amount or nature of the decedent's estate's interest in the asset. Paying the bills, obviously, there could be a dispute with a creditor over the amount or whether the amount is owing at all. And the only person authorized to deal with that kind of dispute would be a court-appointed representative. And the only way to get a court-appointed representative, of course, is to commence a probate and have the court appoint the representative. There could be a dispute about the distribution of the assets. Sometimes disputes arise amongst heirs. They don't agree with what the representative is intending to distribute after the bills have been paid, and disputes can arise there. So the other issue, and so in all of those disputes, the resolution entity is the court. You take those disputes to the court and get them hammered out. So dispute resolution is one form of court intervention. Another form is if the estate is not solvent, meaning the assets of the estate do not exceed the debts of the estate. In that event, we refer to that as an insolvent estate. And when an administrator is appointed by the court to manage an insolvent estate, in effect, that administrator is working for the benefit of all the creditors of the estate, because there's no money left over to distribute to any of the heirs or beneficiaries. All the money is going to go to the creditors when the debts exceed the assets. So in that circumstance, the court will insist on having intervention authority, requiring the administrator, in other words, to come to court to get approval for certain spending decisions, etc. But normally we administer the large majority of estates without court intervention, which means we get to follow a fairly streamlined process. What's the process of probate, by the way? Establishing who's in charge, blessing basically that all the assets have been gathered, all the debts have been paid, and the final distribution of the estate. So usually there's court involvement at the commencement of probate, and if there are no disputes at any of these phases, then the court may become involved at the end of the process when the administrator is seeking to close the estate. Okay. So that's a basic overview. What do you guys do? What if one of your loved ones has passed and you're generally aware that you might have been nominated or you're being relied upon, even if you're not nominated by will or trust, to step in and handle an administration of estate? What do you do? So you've just lost a loved one. Per, I had a question for you. Are you required to go hire an attorney to administer an estate? What are your thoughts about that?
No, you're not required to go hire an attorney. You can do it yourself. It's probably not recommended for some of the reasons you've already stated about the potential for dispute, which the prospective personal representative may already suspect that there is going to be a dispute with somebody, whether it's a creditor or an heir or beneficiary, in which case it would be good to have someone helping you with that situation. But also the probate process, although it's not particularly complicated, there are a number of rules dealing with notices that go out, whether to creditors or whether to heirs and beneficiaries. Other things, preparation of an inventory, for example, there are deadlines for doing those things. And having someone, an attorney, helping with that can make things a lot easier for the personal representative.
So attorney's not required, but useful.
Yes, absolutely.
Good. Thank you. Well, Per, talk to us a little bit. Let's say you've decided to hire an attorney to help you through the process. First of all, what is the attorney's professional responsibility? Who does the attorney represent? I often hear questions about, well, the attorney represents the estate, or the attorney represents the client who's the administrator or personal representative, or the attorney represents the heirs of the estate. You know, I get a lot of questions. What is the attorney's role in the administrative process in terms of who their client is?
Well, they do represent the personal representative, who may or may not also be a beneficiary of the estate, but they represent the personal representative while they're wearing that hat. So if, for example, they're a beneficiary and there is maybe a dispute among the beneficiaries about, hey, who's getting what, we do not represent that same individual when they're wearing their beneficiary hat. There's a conflict of interest, because although we represent the personal representative, there are certain duties that the personal representative owes to creditors and beneficiaries, but the attorney for the personal representative owes some duties as well, not to represent them, but there are some duties about how they act in acting with those people. So that
sounds a little tricky then. If somebody comes to us to assist with an estate administration, and we get into the administration, let's say all the bills are paid, no problem with gathering the assets. Now we're at the distribution phase, and some dispute arises over the distribution of the estate between the heirs, let's say. And one of the heirs happens to be our client as the personal representative. How do we handle that dispute?
Well, we have to look at what is the nature of the dispute. Is it a dispute between beneficiaries, in which case we cannot represent that individual, or is it a dispute as to something that the personal representative is doing in that capacity? Because if it's in the capacity of a personal representative, then that is part of our job, is to represent them in that. So we really have to take a look at what kind of a dispute are we really looking at, and who's involved in it, and then which hat is that personal representative wearing?
Yeah. So what do we do if we find out the dispute does not have anything to do with the performance of the administrator's duties in the administration of the estate, and instead it's just a dispute amongst the heirs that doesn't relate to how the administration was conducted, but rather it's limited to just the distributive share and somebody doesn't agree that the distributive share they're being offered is appropriate under the will or the trust or the law? What do we do if that kind of dispute arises?
In that case, we would refer the personal representative in their capacity as a beneficiary to seek a separate attorney. And that could not be someone from the same firm. because if one is tainted, so to speak, if one of the attorneys is tainted, we all are. Whether we have any knowledge of it or not is because we're in the same firm. So we would refer that person to another attorney to help resolve the dispute among the beneficiaries, so that while they're wearing that hat.
Yeah, good. Okay, thanks for clarifying all that.
Yep.
So, another question I get asked that might be useful for our discussion is, well, if somebody's died and I'm responsible, I have some knowledge I might be responsible to administer the estate and manage the decedent's affairs, how quickly must I act? Are there any rules about how quickly if a probate is necessary, it must be started? How do you approach the time issue about when the administration needs to commence?
Well, it is kind of an unusual situation because the statute doesn't deal with when a probate has to be started. However, when there's a will involved, there is a statute that says it must be filed with the court within 40 days, usually after the personal representative gets the original. But it gets filed with the court, but you wouldn't necessarily be opening a probate at the same time. You could, but you may not be. But I've had people call me the day after the death and say, I need to get a probate started. I have seen cases where the probate hasn't started for years after the death.
Yeah.
Usually, I have not seen a problem in the cases that I've seen with that. I have not seen a problem with the fact that the probate didn't start for years after the death. There may be other issues, but just the mere fact that it didn't start didn't raise an issue. If there had been a will, I don't think I've ever seen a situation where there has been an issue raised about the fact, well, you can't start a probate now because that will should have been filed with the court 40 days after the death.
Right.
But I have also, in kind of talking with people about when the probate should be started, I always ask, has there been a funeral or a memorial service, or do you intend to have one? Because if they would do that, they would typically do that within maybe a week or two after death. And there's usually nothing in a probate administration that needs to be done so quickly. And there's enough details of arranging for that kind of thing, but also grieving and the stress involved with that I suggest do that first, then let's get going on the probate. In addition to the fact that to start a probate in the state of Washington, you have to be able to provide an original death certificate. That takes a little while to get. And so even if you were to start getting everything prepared the day after the decedent died, you may not be able to go to court, to whether in person, when we can do that again, or even by mail or otherwise, until you have that death certificate.
How long, do you have any experience about how long that generally takes to get
the death certificate?
Yeah.
I've been hearing different numbers, and I know that they have recently changed the people that can apply or request that. I've seen it come within a couple of days, but I've also seen it take a couple of weeks, sometimes because there's an error on the death certificate that needs to be corrected.
Yeah, that's been my experience too. It kind of varies. And oftentimes, if a funeral home is involved, they're the ones as part of the funeral intake process that are typically getting you to sign paperwork, and typically they're processing the death certificate request. And
yes,
but you can do that yourself as well.
Right.
But you're right. It can take some time. Sometimes it happens very quickly. Sometimes it takes a couple of weeks. Okay, great. So no real rules on how quickly the administration must commence, whether it's probate or non-probate. Obviously, though, the sooner the better normally, and I do follow your suggestion as well. I always talk to my clients about considering waiting until after the funeral or memorial has occurred. It just seems to be a natural time to start to switch over from the grieving process to now taking care of the business that needs to be taken care of. But I've got a lot of clients who are, they want to get started right away, and we can help them do that. but I encourage people to get started sooner rather than later in terms of after the memorial or the funeral, not waiting a year or two or three for the reasons I mentioned earlier. All right. Well, Sarah, let me ask you this. So, loved one has passed away, and somebody has contacted us to assist them with an administration. Give us an idea about the kind of information they should plan to get to us to get started, whether that's by meeting or by conference. What kinds of information do we need to start figuring out what form of administration is going to be required and what the estate looks like, that might dictate certain actions to gather appoint the person in charge, give them the legal authority, gather the assets, paying the bills, and ultimately so that we're able to distribute the assets properly and then close the estate. What information do we need to get started?
Well, it's not strictly necessary to have everything at the beginning. It's incredibly helpful if people can come in bringing that original copy of the will and whatever codicils might be, the trust, if any amendments, power of attorneys, these sorts of documents which outline the instructions that we have to follow. It's also great, as Per mentioned, we're going to need that death certificate if we need to open probate. And this is a great chance to make sure that everything listed is accurate. Bringing in financial statements, if they can be found, preferably as close to the date of death as possible, or just any other information that can give us a general understanding of the assets and the debts that need to be dealt with as part of this administration process.
When you use the term financial statements, are you referring to something prepared by an accountant, or are you referring to something else?
It's what's most, the easiest thing to find is often going to be just the statements that you'll get in the mail regularly from bank accounts and retirement accounts, mortgage statements, credit card statements, really whatever is going to give you the accurate information, be the easiest thing to get.
It's not like you need to go to a CPA, review all the financial stuff before you go meet with the lawyer and have the CPA prepare formal financial statements. That's not what you're referring to. You're referring to the bank statements and the asset statements that normally come. Is that right?
Exactly so.
Yeah.
Yes.
Okay. All right.
And then finally, just bring in a family tree, something that has everybody's names, nicknames if possible. You don't need to go 200 years up to your great-great-grandparents, but it would be great to have your loved one's spouse or partner, if they had one, their parents, their siblings and their children, and also, of course, their own children and grandchildren. Just make sure that we have an accurate understanding of who any potential heirs and beneficiaries might be, whether for distribution of the assets, notices, and the other things that we need to do as part of the estate.
Yeah, one of the things I always try to mention about the family tree information is I'd like to get correct spellings of everybody's names. I'd like to get dates of birth, because sometimes we have to handle distributions to minors a little differently than we do to people over the age of 18, depending on the controlling distribution, the will, the trust, or the law. And then I also like to make sure I understand the relationship amongst the parties, sons, daughters, nieces, nephews, siblings, parents, grandparents. I like to make sure I have a summary of all of that. Okay, good. So I'm sorry, maybe you mentioned it and I didn't, I glossed over it. What about the debts of the estate? Is it helpful to have an understanding of what the debts might be, and how can a client quickly and efficiently assemble that for us?
Mm-hmm. So, going back, you can bring in mortgage statements, credit card statements, any other awareness that you have or can gather for both the assets they hold, but also the debts as well. We need this because, as you mentioned earlier, we have to tell the court if the estate is solvent or insolvent, whether it has enough assets to cover the debts if we decide to open probate, but also going back to the main purpose of the estate, a large part of which is to pay off any debts that there may be and to distribute the remaining assets. So having an accurate understanding of that information is incredibly important. And those statements just help to give a more accurate understanding if they can be found.
Sure, sure.
And Matt, if I could step in there for a second.
Yeah.
This does not have to be particularly with the debts, well, with the asset values as well. This is not something that has to be down to the penny, because they've had a couple of weeks. There's been a death. There's been potentially a funeral or memorial service. So it's not like there has to be an exact number. We just have to be able to show the court that it's solvent. So if we got a pretty good idea of the general range of the asset values and the general range of the debts, and so an approximation, that's what we need at that point. We'll have to get more detailed as the administration progresses. But to start with, that should reduce the stress level a bit on the personal representative, that they don't need to be down to the penny on that information.
Yeah,
Exactly so.
I'm glad you mentioned that, Per. It is a stressful time. Somebody's just dealt with the loss of a loved one. The administration process is unknown. When you don't know what you're doing, you're a little fearful. You don't know what you need. You don't know what you don't need. That's exactly what we're here to guide you through. So really, you should do your best to gather this information, the best that you can. Anything missing, we're here to say, hey, we need some missing information you didn't bring. Anything we might need appraisals for, or to sharpen our understanding about values, that's part of the process and guidance we'll provide. And as Per suggested, don't let your grief freeze you into inaction. Do the best you can to gather this information, and we're here to help you with all the rest, because we understand the process that we need to go through to get to the end of it. Yeah, thank you, Per. Great idea. Hey, Per, talk to us a little bit. I know we've been talking a lot about probate, but as we get ready to wrap this up, talk to us a little bit about when probate's not needed. What circumstances or situations might exist when we're meeting with a client or trying to figure out right off the bat what the estate looks like, what the asset creditor issues might be, what the distribution issues might be. But also what I'm saying is that initial meeting for me is also involves trying to figure out whether probate's going to be necessary or whether some alternate form or of administration is appropriate. Give us just a few general thoughts about what assets wouldn't require probate, what forms the estate might be in that we wouldn't require probate. Just a couple that occur off the top of it.
Yeah. One of them is payable on death accounts or transfer on death accounts, whether it's a bank account or an investment account. Those are not considered probate assets. They're governed by the documents that were used to create or change certain aspects of it, like the naming of a beneficiary. I know that I've run into situations with bank accounts where all the bank needs is the death certificate and proof that you're the beneficiary named in the documents that they have, and that's all it takes to get that asset transferred. Another one is joint tenancy with right of survivorship.
Let me slow you down here and
Sure.
ask a little bit about that first situation. So if the estate only contained what we call pay on death or transfer on death financial assets, as in the case of an elderly person who might have sold their real estate, transferred much of their personal property away, and all they had now was money that they were living on, and they designated that account to transfer upon their death. An issue that comes up for me is, can that transfer happen with disregard for the person's debts? So in other words, can those assets transfer to the POD beneficiary as a way of avoiding having to pay any of the debts?
Well, the problem there is that the estate, and they're still an estate, even though it's not necessarily maybe a probate estate, still has those obligations. Yeah. So they could be charged for that. And otherwise the estate would not be involved. But yeah, if that's the only asset that there is, it could be charged for debts of the estate.
Yeah.
Or debts of the decedent that now become debts of the estate.
Right. So you were starting to mention another kind of asset that might be held as joint tenant with right of survivorship. That's a form of ownership that allows for the transfer of that asset by operation of law, right?
That's
Meaning
right.
The will or the trust don't dictate Instead, that form of ownership dictates where that asset goes. Is that right?
That's right. And it could be in any number of forms. I mean, there could even be bank accounts that are joint tenancy with right of survivorship. Could be real estate. I think those are probably the two, and investment accounts are probably the most common that might be held as joint tenancy with right of survivorship. But merely the operation of law is what determines how that gets transferred. I have run into situations where, for whatever reason, and I've seen this with payable on death accounts too, for some reason, they're wanting to see letters testamentary or letters of administration, which shouldn't be necessary, but it causes a problem. And depending upon the size of the account, it could be a significant problem if the holder of that account just won't allow for the transfer without that documentation.
And remind us, what are letters testamentary or letters of administration? How do we get those, and when are they issued?
When a probate's opened, if there is a will involved, then there's letters testamentary that are issued by the clerk of the court after the probate is opened. If there's no will, then they're called letters of administration, again, issued by the clerk of the court, that identify the personal representative and indicate that they have the authority to act on behalf of the estate.
Yeah. Okay.
We also have things like small estates. In the state of Washington, if the net estate is under $100,000, you can do it by a form of affidavit that does not require court involvement. It's not filed with the court, and there are a lot of protections both for that individual, but also the person who has been presented with such an affidavit, because they're holding property that belonged to the decedent, and they want to make sure that they're giving it to the right person. As long as the affidavit has been properly completed, then there are some protections for them as well. If there's a trust involved, trust is not governed by the probate statutes. Sometimes you'll have a trust, but there's what's called a pour-over will, which takes care of whatever was not in the trust goes into the trust, and then all the distribution is under the trust.
Right.
But if there isn't, then the trust administration, that's just limited to, that's the trustee, unless there's been some other reason that court involvement has been required.
Right. So all of these issues, Per, that you've mentioned, in addition to those four concepts I mentioned about the general administrative process, these are all issues that we're looking for to resolve or to get more information about as we understand the estate, kind of at the initial phase of the client meeting with us and bringing in information. These are all issues that we have to think about, we have to anticipate, and we have to deal with, because all of these issues will guide or govern in one way or another how we actually conduct the details of the administrative process. Is that right?
That's right. Yeah, because when you get answers to those questions, it may turn out that probate is not necessary at all.
Yeah. Good. Well, listen, anyone who knows me or has met me knows that I am often long-winded, and I see that I'm long-winded today. All I really wanted to do today was introduce everybody to the concept of administration, what it is, answer a few common questions that I get, and talk about the beginning of it. Because really, if you can gather the information we've discussed, we're going to take care of ensuring that whatever issue may be presented by your situation is properly addressed in the context of the administration. We do a lot of administration work. We do a lot of estate litigation as well, which gives us a lot of insight into the administrative process. And having a good handle on the administrative process helps us with the litigation side of things as well. So, listen, I know that we advertise this with a little bit of Q&A opportunity. Let me do this. We did receive in advance of the seminar a series of questions here. Let me try to run through these quickly, and then we'll wrap up. And I would invite anybody who has a question, feel free to contact Sarah, Per, or I. We'd be happy to spend a few minutes on the phone, make sure your question is answered, and get you pointed in the right direction. Here's a question. Is there a way to search for unknown assets, safe deposit boxes, or bank accounts known? The answer is yes. if you don't know very much about a decedent's estate, one of the things we always advise you to do is, first of all, search the decedent's personal records. Secondly, make sure you take control of the mail so you can expose yourself to financial statements, debt statements, the things that Sarah was talking about. So you yourself might be able to learn a little bit more about the decedent's estate. In addition to watching the mail and going through the records, we can hire a private investigator if we need to. And frankly, once an estate is commenced, if as an investigatory tool, we can also issue a subpoena. There have been times when I have issued broadcast subpoenas to all the financial institutions within a particular geographic area. A lot of times I get no response because the financial institutions aren't aware, but we can issue subpoenas. And if we hit the right bank or financial institution, we will get a response and learn about assets held at that institution. Me and my two brothers inherited some properties that run a business at rental spaces. How do I distribute when the properties need to stay together for business purposes? The short answer is generally you're going to distribute interest in an entity that owns that business. So whether it's a corporation and you distribute shares, whether it's an LLC, you're distributing unit or membership interest in the LLC, and you accomplish the distribution of the asset generally by distributing the capital form of the entity itself. When does a trust need to be dissolved after death? The answer there is it really depends on the terms of the trust. Some trust will distribute in further trust. Some trust will distribute outright. So really the answer is dictated by the plan as expressed in the trust. Let's see, we did touch on 4 and 5, and I'll have to end with this. The questions are, is there a notification of some kind required when final distributions are made to beneficiaries? And then 5 is, when do you know all tasks are completed and the estate is settled? Well, I referred to this generally earlier. There are notice requirements. Any estate that's closed in secret is probably not properly closed. And problems come up in this area all the time. I'm talking with people, hey, I was an heir and I was told my brother closed an estate and I didn't get anything, or I don't have any idea what happened during the administration. We can go back generally and compel all that information. And if something was done improperly, we can make our best efforts to set that straight. The specifics of that, though, we would have to know more about and guide and advise you about what would be necessary in that circumstance. But generally, an estate, whether it's a trust estate or a probate estate or even a non-probate estate, you can't avoid paying the rightful bills and you can't avoid making the rightful distributions properly. And if those things have happened, there are ways to set all that straight. Okay? Listen, I'm sorry to rush through, and
Hey, Matt, quick question.
Yeah.
We've got a question from Ben. He'd like to know, what is considered reasonable fees for your role working as the personal representative of the estate?
Yeah, great question. Sorry, due to time, though, we're going to have to make this the last question. So reasonable fees generally are what the court will approve as reasonable. What I'm experiencing is generally between about $25 an hour and $50 an hour, depending on the complexity of the tasks that the personal representative was required to perform to gather the assets, pay the bills, or make the distributions. The more complex, the higher the hourly rate. But generally between $25 and $50 an hour is approved. Certainly there can be some very complex litigation or other issues that arise that might require special knowledge, special experience, or the personal representative to hire people with that special knowledge or experience to assist in the estate administration. The court will approve compensation for professionals or fiduciaries at a higher rate, but that rate has to be justified. Let me say one more word. One of the other things I do when it comes to fiduciary compensation is I advise the client, listen, you've got to keep contemporaneous real-time records of the time and the description of your activity that you're engaging in. if you get to the end of the administration and then decide to try to make it up over the course of 5 or 6 or 7 months of the simple administration or the 3 years of the complex administration, you're going to have a hard time justifying that to the court. So if you expect to be compensated reasonably for your time as an administrator, please keep contemporaneous records. And I always advise my clients more specifically about that. Hope that answers your questions. Hopefully our comments and about the commencement of estate administration and what it is have proven helpful. If you've got questions, however, please feel free to contact any of the three of us here at Beresford Booth. Have a good day. We'll be back with more information and more discussion about this process in future webinars. Thank you.